Good afternoon. Well, almost afternoon, everybody. We are just starting our new series for the Special Ed Legal Clinic, and we are going to wait a couple minutes to let everyone file in. There we go. I see people joining now. We're just going to give everyone a minute or two. Hopefully I'm still here. I just got a notification that my internet connection is unstable. We're just gonna give everyone a minute or two to log in, as I'm sure we're coming in for our lunch break right now. And then we will get started.
Renee, just so you know, we can see you and hear you. It stuttered for a second, but I think we're in good shape.
Okay, awesome. Thank you. Luckily, I'm only doing an introduction and I don't have to do the presentation, so I don't have to worry about that too much. For everyone who's just joining us, thank you for joining us. We are going to get started in about a minute or two. Just waiting to make sure everyone can get signed in okay. Thank you all for being here. Hi, Danielle.
Hi.
Just giving everyone a minute to, oh, she just left, but giving everyone a minute to sign in here. Do you want to wait until 12:02 mark or get started?
No, I think we can get rolling.
Get rolling? Okay, awesome. Well, thank you everybody for being here. This is the Ohio Special Education Legal Clinic. We are a collaborative of 3 independent organizations, Abdenor Weiker, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities. My name is Renee Stromsky, and today we have Mark Weiker here from Abdenor Weiker as well, AW Law, All Law. And Mark will be presenting today on understanding student privacy rights under FERPA. This is part of our new series, our 2025-2026 school year series, titled Advocacy in Action. The Special Education Legal Clinic takes place on the 3rd Monday of each month, unless otherwise noted for some of the upcoming holidays in the winter, from noon to 1 p.m. And during that time, which is now, we'll have a group workshop for parents and educators. And the last 15 minutes of the workshop is a Q&A panel of special education attorneys. Mark has also graciously allowed me to interrupt him if we have any questions during the presentation. So if you do have a question that you'd like to bring up during the presentation or afterward, you can use the Q&A function at the bottom of the Zoom screen, and I will be monitoring that. And then afterwards, we have individual guidance sessions with our attorneys from 1 p.m. to 3 p.m., which you can sign up for at our website, lawyers4students.com/legal clinic. That's lawyers4students.com/legal clinic. And I will say this will be recorded. This session will also be recorded and available on the same website a couple days after. Give us till the end of the week at least, and we'll get that uploaded for you guys to be able to review. And if you have any questions, please feel free to reach out to one of us. And just before I turn it over to Mark, I will say that our next session will be next month, on Monday, November 17th, and it'll be a presentation by Steve Pelton of the organization We Thrive Together, just talking about their organization, which is making sure that individuals with disabilities in the transition period and adulthood are being included in our community. So without further ado, I will turn it over to Mark. who, as you can see on the screen, who, as I said, is going to talk about understanding student privacy rights under FERPA. And if you have any questions, you can use that Q&A function, and I'll be happy to jump in and ask Mark to answer them. So, Mark, take it away.
All right, thank you very much, Renee. My pleasure to be here. I have provided this presentation in the past through the Special Education Legal Clinic, but I've added a few details that we'll talk about today, but it is available already on recording from a 2023 series that we did, but it is, again, updated, and I thought it was a good time to present it again to kick off this new series. So thanks again, Renee. I want this to be interactive, so if anyone has questions, feel free to drop them in the chat box. Renee will interrupt me when appropriate. And this session, as you can see, is Understanding FERPA and Student Privacy. FERPA, if you didn't know, is the Family Educational Rights and Privacy Act. It's a federal law, and it governs student records that schools maintain. And I like this topic a lot. I've presented it, or I presented on FERPA through the course of my career, both as a school attorney and as a student rights attorney. I really like it. It's one of the very few federal laws which seems easy to understand, and which is written, the actual regulations for the law are written in kind of a Q&A format, very easy to read and understand. It's not to say that they're not comprehensive, because they are, but it is, in terms of laws go, relatively straightforward. I like to provide a little bit of the historical context leading up to FERPA, because I think it helps understand the purpose of FERPA itself. So as it shows there, FERPA was adopted in August of 1974. The society at the time was very interested in privacy, in particular, privacy, or what the government was doing with our data, the data that it collects, at various levels through various agencies. The timing is interesting, because if you consider, and you might have gathered from the pictures there, that Nixon resigned on August 9th of 1974, and then President Ford took over. And then only, I guess that would be about 11 days later, the FERPA bill was signed into law by President Ford. And prior to FERPA being passed in that year, the government had passed a law called the Privacy Act. And what that did, it governed the use of data for government employees. So any information that was collected on governmental employees, whether that be, health records, workers' comp records, information pertaining to where they lived, home address, children, that type of stuff. The Privacy Act of 1974, prior to FERPA, really limited what the government could do with that data. So privacy was a big issue at the time. Of course, Watergate helped that, or aided that. And then FERPA, as you see there, was drafted in response to the growing evidence of the abuse of student records across the nation. And that was a quote by Senator Buckley, who was a sponsor of the bill. One co-sponsor of the bill was a very young, as you can see there in the bottom right-hand corner, very young Joe Biden was a co-sponsor. And the question at the time is, what is the government doing with our data? So FERPA was passed to restrict schools' use of information that they had, in this case, in particular on students. And I want to take a step back, because with parents especially, but also sometimes with educators, it gets conflated. Public records and education records can get kind of mushed into this one category, or conflated. So I think it's important to understand the difference between the two. So public records, every state has a public records law. And that public records law pertain to records that are maintained by public institutions. So in Ohio, this is 149.43. And then the definition of public records is in 149.011. And that is just any item that's stored on a fixed medium. So it could be electronic, it could be on paper, it could be on microfilm, whatever. And then it's created, any document that or item that's created, received, or sent under the jurisdiction of a public office, and then documents the organization, functions, policies, decisions, operations, so on and so forth. So that definition, if it looks entirely broad, it is entirely broad. So it covers about any document, any communication, anything that is received by a public agency. And then it's stored in any way. So the only thing it really doesn't include is things that are not considered a record at all. So conversations, those types of things. So even a text message for a public agency can be considered a public record if it documents the organizational functions, policies, decisions, so on and so forth. So that's a big umbrella term. It is important to understand that public records laws are passed because the records that are maintained by those institutions, those agencies, belong to the public. They can't be deleted, they can't be hidden. And for states like Ohio that have public records laws that require their disclosure, they have to be maintained and they have to be produced to anyone who makes a request, a public records request, so that that information, is available because it is owned by members of the public. So one good example of this, we use it all the time, is if we can in Ohio request a personnel file for any public school teacher, for any principal, for any faculty member of a public institution, those are all public records, and the entire personnel file is available to any person, or at least any citizen of the state, who makes a request for that record. There are some exceptions to that, which we'll talk about, but of course they have to redact Social Security numbers, they have to redact workers' comp records because they relate to the employee's health, so on and so forth. So if you understand the big umbrella term that these public agencies maintain records that belong to the public, then there are exceptions to that. And public records, like I mentioned, does not include medical records that they may maintain, confidential law enforcement investigatory records. So, the sheriff's department is a public agency, but if there is a pending investigation, they do not have to produce law enforcement investigatory records during the pending investigation. Just one example, but we're really looking at V here, the exception, records, the release of which is prohibited by state or federal law. And we came here to talk about FERPA. FERPA is the federal law that says that student education records must be maintained in confidence by public schools. So it is an exception to the Public Records Act of all states. Okay, here are the two main components of FERPA. And if you don't take anything else from this workshop today, I want you to understand that these are the two main components of FERPA. So the law not only guarantees access to student education records to both students and parents, that's number one, but it also limits access to third parties. So it's in the same law, it says you have a right of access as a parent and nobody else does. And nobody else can get the information so long as it's considered an education record. And we'll talk about that definition. So there are exceptions to number one. So guaranteed access of education records to students and their parents. There are exceptions based on the definition of education record and the definition of a student or a parent. So we'll talk about that. If it's not an education record, it doesn't guarantee you access. Keep in mind, though, if you're requesting records and it's not a student record, it may still fall into the category of a public record, in which case you can do a public records request and receive it that way. Next, it limits access to third parties, and you'll see, so schools are not allowed to disclose education records that contain personally identifiable information of any student to any third party, but there are lots of exceptions. And those exceptions, we'll see. We're going to go through some of the primary exceptions that relate to student and parent rights. But there are lots of exceptions that allow the information to be disclosed to third parties. One exception that you might be aware of is a subpoena. If the information's subpoenaed, then it may be produced to the subpoenaing party. That's just one example of one of the exceptions to disclosure to third parties. Health and safety emergency is another exception. Okay, now let's look back. I want you to remember where this falls in. So the definition of parents and eligible students falls here under the exception. So you have a right of access so long as you're a parent or eligible student. So the definition, again, is important for the right of access and who needs to provide consent, because you can consent for that information to go to third parties. But for right now, let's think about the right of access. So parents, this includes a natural parent, a guardian, or an individual acting as a parent, even temporarily, unless there's a court order that says otherwise. And it comes up a lot too that, if the parents are separated or divorced, both parents maintain the right to receive education records and to consent for those records to be produced to a third party, unless the court says otherwise. And a lot of times, when a divorce is finalized, the court will identify one parent as the educational rights parent. But not always. Sometimes the divorce happens and nobody's been identified as the school right or educational rights parent. So long as there's no court order that says one parent has been divested of that right, then both parents have a right of access to the education record. They have a right to receive the information upon request from the school. And those rights of a parent automatically extinguish and are transferred to the student as soon as the student turns 18. That's true even if the student is still a senior or still attending high school. So those rights transfer to the student. However, one big exception to that is that parents retain a right of access for their dependents, even if their child is 18 or older. So that's true in high school, and in most cases, the student is a dependent for tax purposes, and that's what matters, a dependent for IRS tax filing purposes. Then parents still have a right of access to the education records of their child, even though the child is 18. That continues to college, so long as they're a dependent, then parents have a right to retain access or to see the education records. So eligible student, right, like I mentioned, rights transferred to the students at age 18, or the rights transferred to the student for the sake of post-secondary education when the student is attending a post-secondary institution. So if a student is attending, or I'm sorry, in high school taking post-secondary option or college credit plus classes, then the university in which they're taking the courses will look to the student to provide consent or to request education records, and generally do not provide a right of access to the parents because now they're attending college courses. The high school typically, because the student is attending high school, will still allow the parent a right of access until the student turns 18, and if the student is a dependent. A little bit confusing, but just know that the rights transfer to the student. So the schools need to look to the student to provide consent to give records to a third party once the student is 18. Okay. So what is an education record? Only education records are covered by FERPA. We'll talk about this a little bit more in detail, but FERPA only covers records. That's it. And specifically only education records. So you only have that right of access, and it can only be prevented, or it's only prohibited to give those records to a third party if it's an education record. So if you understand that an education record includes records, documents, so on and so forth, which contain information related to a student. If we're a little bit more specific there, it's personally identifiable information related to a student. So it has to be a record that identifies the student in some way, personally identifiable information, and which is maintained by an educational institution. It has to be held by that institution, not necessarily a teacher, not necessarily a teacher's aide or a counselor, but it has to be held and maintained by the educational institution. Although, if you think about that definition, it applies to lots of different records, certainly special education records. Certainly discipline records are considered education records because they are It contains information related to the student, and it's maintained by an educational institution. We'll keep coming back to that definition. In 1974, in the first 4 months of the law being in existence and effective, FERPA had a laundry list of records that were considered education records. So the list here: academic work, IQ tests, psychological tests, behavior reports, disciplinary files was one of them, class rank, observations. And that laundry list was good, except there were lots of examples of education records that weren't covered because they used this list. So within 4 months of FERPA being passed, they passed an amendment which got rid of the laundry list and then went back to this education record definition. So it a much more broad definition that covers a lot more records, and there's no more laundry list. However, this laundry list is helpful as an illustration of what would be considered an education record. Okay, through the course of several court decisions and then also guidance from the U.S. Department of Education, we've learned in some cases what is not an education record. So here are some examples of things that are not education records. And a lot of times it comes back to the definition of education records. So teacher, counselor, and personal notes. So these are things that might be scratched on a piece of paper. Teacher takes some notes for him or herself. The counselor writes some things down. Maybe even an administrator does the same thing. But the guidance from the U.S. Department of Education and then a subsequent court case said when the information is in the sole possession of the maker, SPOM, that is not an education record, so that the parents and student do not have an affirmative right to have those records because they're in the sole possession of the maker and not maintained by the school district. When they say maintained by the school district, they're thinking about some central database. So if it was a physical file, it would be in the office like in the old days, or if it's on a server that the school maintains. That's when it's held by an institution and is considered an education record. Notes from a teacher, even in a lot of cases, the curriculum would be an education record because that's maintained in a central office, typically put together by a curriculum director. But just individual teacher counselor notes, which are maintained by the teacher or counselor themselves, are not an education record. Law enforcement records are not maintained by a district. Now, there is kind of an exception to this. On college campuses, sometimes there's campus police. That isn't a part of the agency or part of the institution. In that case, those law enforcement records are education records because they're maintained by the school district, or in this case, the university. So law enforcement records, this comes up too when we have a school resource officer placed in the school. It depends who that school resource officer is employed by. And it gets tricky because sometimes they're employed half and half by the school district, or at least paid half and half by the school district and, let's say, the sheriff's office. And so to the extent that they are maintaining records on behalf of the district or employed by the district, it is certainly arguable, and it's a pretty good argument, that those records are education records covered by FERPA. To the extent they're an independent, employee of the sheriff's office, they are not covered by FERPA because they're not maintained by the school district in that case. Personnel records are not education records because it doesn't contain information related to a student. There could be an exception to that if there's a disciplinary file that identifies a student by name in a personnel record, but that information generally would not be in a personnel file. So personnel records are not education records. As I mentioned, though, personnel records are in most states public records. So you can get access to those just by making a public records request. You don't have to be the parent of a student to do that. You just have to be a citizen. Treatment records of college students, this was kind of in the gray area. So they issued some guidance on this at the U.S. Department of Education. If college students get treatment from the health, the student health center, or some other center on campus, then those treatment records are considered confidential and not subject to FERPA. Alumni records. This one's a little tricky because any record that's created while a student is attending through graduation is an education record. But if an alumnus comes back and volunteers or attends an event or is on a board, anything that's created post-graduation is not an education record. So they're not protected in the same way. And then again, the student and parent don't have an affirmative right to those records in the same way. In the same way they do for records that are created when the student was a student at the school. Student graded papers. This is a Supreme Court case. OWASA was in Oklahoma. This is a school district. And this is a situation where students take a quiz, and then to grade the quiz, they exchange papers, and your neighbor grades your quiz and marks you, gives you a score, and then gives it back to you. And I hope that you're thinking by now that, well, that wouldn't be an education record because it's not maintained by the school, and you would be exactly right. Now, this one went to the U.S. Supreme Court, which again was interesting, but is a pretty straightforward, unanimous decision that student graded papers, because they're not maintained, they're not collected by the teacher, the scores weren't recorded in a grade book, and the school didn't maintain the records or the papers in this case, that those are not education records. And then this is a bonus that I added when I did this presentation during COVID. Observations are not records. So FERPA protects records. It has to be a physical type file, electronic or otherwise, and observations. So what you see students doing in the hallway, what you see students doing in the classroom, what you see students doing on the playground, those are not education records. They're not, number one, they're not confidential in the way that education records are. And there's no prohibition on some third party viewing what the students are doing or observing what the students are doing in the classroom or in the hallway. This came up, as you probably can gather, during COVID, when we were all watching our students attend class and watching other students answer questions online. And that's not to say that schools might not have policies about who can attend class and who can sit in on a class. And for the most part, I think most school districts are open to that if you want to come and sit in for a class, so long as you don't overextend your welcome. But observations themselves are not education records and are therefore not confidential in the same way that education records are. All right, want to just take a pause and make sure there are no questions, or to give anyone a.
That's actually perfect timing, Mark. We just got 2 questions coming right as you were taking that pause. So awesome. The first question was, if an observation is done as part of a special education evaluation and information from the observation is included in an evaluation report, do those count as educational records?
100% yes, because once those observations are recorded, now we're creating a record, number one. And then not only are they recorded, then they're put into a special education document, whether it be an evaluation or some progress report. Those are maintained by the school district. So it goes from just an observation with no record to an observation that's been recorded to an observation that's been then maintained by the district and contains information related to a student. 100% falls into the category then of an education record. Very good question though.
Thank you. And the next question is actually very similar. It just says, I would assume that observations made during an FBA, which is a functional behavior assessment for those who don't know the acronyms, or a behavior intervention plan or a BIP are confidential, or is that not accurate?
Mm-hmm. Yeah, number one, it's recorded. So assuming the observations are documented in some way, they are recorded. And then, put into to inform with the purpose of informing the the behavior plan, the assessment or the plan, then absolutely they become education records. So yeah, that's kind of the the path in which those things take. As soon as it's recorded and then put into a record that's going to be maintained, they're absolutely protected. And then another situation, I've had this question in the past, and I want to answer it because some of you may be wondering. A teacher can't stand at the front of the class and read off of an education record. Let's say it's a, heaven forbid, like a, special education record, an IEP or an evaluation, or even a disciplinary record. But the student, you may have, someone in the class, other students, or maybe even a parent may have observed what happened. And that's not a FERPA violation, just to observe what happened, or for the school to allow you to observe what happened. But anytime you're taking information and then reading off of it or sharing that information with a group, that could be a FERPA violation, because you're sharing information directly from a record to third parties without a privilege. So there is a limit to that, but I just like to share that observations are not records, and they're generally, unless one of those exceptions that we've already talked about here apply, are not covered by FERPA. Looks like there's one more question, maybe.
There is, and thank you for that. The question is, what kind of document can be used when a student turns 18, but the parent still needs to make decisions for the child?
If there's so unless there's some determination that the student is not competent to make their own decisions, the decision-making authority under FERPA goes to the 18-year-old student. So, that consent has to be in writing, or at least by email. There has to be some text consent. If the student's not able to do that, I'm sure the school will work out a plan for the parents to be able to do that. But technically, the consent has to come from the student in that case. And don't confuse the idea that if the student is still a dependent for tax purposes, the parents still have a right of access to the education records. But under the law, the student is the individual where the right transfers and who must provide consent to release those records to a third party. Again, unless there's some determination that the student is not competent to do that, and the student has a guardian who's going to make that decision for them. Okay.
Thank you. Yeah,
So,
that's all we have right now, so you can feel free to move on.
Okay, I'm just going to back up one step just so we get into the context here. So recall, we've talked a little bit about guaranteed access. And then the second part of FERPA is that it limits access to third parties, but there are 17 exceptions that allow disclosure by the school to a third party without consent, without the student's consent or the parent's consent. So here are some of those exceptions. And when I used to advise schools, we would work through every single one of these exceptions. Some of them are commonsensical, but the ones I have bolded here those are the ones I'm going to touch on, because these are ones that I see come up even on the student rights side of things. So number one, employees of the school with a legitimate educational interest. That's not every teacher who works for the school. In fact, teachers have been and will continue to be disciplined for accessing student education records on their system when they don't have a legitimate educational interest. And that's maybe, of course, a teacher who teaches the student will have a legitimate educational interest. Generally speaking, if the student participates in extracurriculars or athletics, the athletic director will have a legitimate educational interest to make sure that the student is eligible grade-wise to participate. I have seen a case where a coach, even though it was the coach of the student, accessed the files improperly and was determined not to have a legitimate educational interest, even though he coached the student, because the coach wasn't responsible for determining whether or not the student was eligible. So that's important, legitimate educational interest. Any of the employees in the district that have that interest, they may access the student education files, grades, anything that would be in the file. So to a transferring school, Ohio has a statute and most states do, but there's also an exception in FERPA. So information, the student record, student cumulative file can be provided to a school in which the child is transferring upon request without the consent of the parent. Now, a lot of transferring schools will still get consent from the parent to make the request. And as an example, we always get consent, signed consent from a parent to access student education records or to make the request from the school district when we are representing a student, because it's easier just to provide the consent. That way there's no question about whether or not the school has the authority to transfer the file to us, or in this case, and number two, to transfer the file to a transferring school. By subpoena, I mentioned that a little bit earlier. So if records, student education records are subpoenaed pursuant to some court case or administrative filing, then the records can be produced from the school to the third party who issued the subpoena. Now, there's a weird kind of exception here. I've never seen this in the law except for under FERPA, in that the school has to wait for a period of up to 45 days to give the parents and student a right to intervene in the court and move to quash the subpoena if they want to. So just kind of a little waiting period before the school has to comply with the subpoena. And that delays, when somebody is issuing a subpoena that is requesting student education records, it does delay the process a little bit. And then to parents of dependents, I mentioned that for IRS tax purposes, they have a right of access. Schools may transfer the files to them so long as the child is still a dependent. To health and safety personnel during an emergency. So you can imagine any emergency that might come up. This is a health and safety emergency. So it could be, a school threat. It could be, a student who's been diagnosed with COVID. This happened during, the pandemic, in that the health-related information was given to the local health departments, and sometimes the state health department to help keep the count of the number of individuals with COVID in any given school district. And with this exception, health and safety emergency exception, it's the information that can be provided to the health and safety personnel is only that information that they need to address the emergency. So in the case of COVID, it was only the name of the student and the fact that they had been, they had contracted COVID. For, a school emergency, a safety emergency, it's only the information that, law enforcement might need to help address the emergency, and not beyond that. It doesn't mean the entire education record is available. It doesn't mean that it's available forever. It's only that information and for only that time that they need to address the emergency. And then number 16, so any record can be provided to a third party so long as the personally identifiable information of the student is redacted. So if the student's identity cannot be gleaned from the document because the document's been redacted sufficiently, then that information can be given to a third party without the parent's consent. So any record with redactions. Now, if you can't sufficiently redact it, or if you redact it and you can still glean the identity of the student, then the document's still protected under FERPA. And you got to keep in mind, now this is pretty unique with FERPA too, you got to keep in mind the information that the requesting party has. The school has to keep in mind the information that the requesting party has. So if the requesting party is requesting a record of a student that they know their identity already, the school may withhold that record, and a lot of times they do, because they know even with redactions that the party requesting the documents will know the identity of the student. A little nuance there, but more important for school officials than parents. Directory information is a big exception. This is as you might have been wondering, how can a school publish a yearbook? How can a school publish a playbill that has a bunch of student identifying information that the school maintains? Well, this big directory information exception applies so that schools can do just that. They can publish athletic, athletic directories. They can publish, playbills. They can publish, anything that would include a list of students or the list of students who participate in certain activities, and maybe including the grade level they're in, sophomore, junior, senior, so on and so forth. And directory information includes generally the student's name, what they're participating in, both academically and athletically. So all of those things are an exception, which that information can be produced to third parties without parents' consent. Now, one other caveat to directory information is that every year in the student and/or parent handbook, the school has to notify the parents that they can opt out of their students' directory information being published in the yearbook or any other document. So that has to be published every year. You have the option to opt out of that, and if you do, then the student information won't be in those publications. Another big, this isn't, other than in the text of the statute itself, this isn't an exception, but anytime consent is given by the eligible student or parent, that is an exception. It allows. So anytime there's any question, or maybe the school's not aware that they can provide the information to, let's say, juvenile court officials or accrediting organizations, all you have to do is provide consent, and then the school has the authority through the parent or student to provide any education record to a third party. And then, of course, number two, if it's not an education record, then the school doesn't need consent to produce it. It may even have to produce it as a public record. So I see a question in there. Renee, do you want me to pause here?
That would be great. Thank you.
Sure.
The question was just, what do VC and NFSA stand for?
Oh, okay. Yeah, so back here, one exception is the final results of discipline to a victim of a violent crime or a non-forcible sex act. And I'll explain that one a little bit. So, this is comes from the campus crimes law that allowed victims of those types of crimes so 11 is victims of those types of crimes to receive the discipline that was issued to the perpetrator in those cases. Because otherwise, can you imagine being a victim of a crime on campus and then not knowing if that student, and let's say, and it would have to be a student, if that student was punished in any way or sanctioned by the university? It was just an unjust result or outcome under FERPA, and universities were holding that information. Not that they thought they should, but I think they felt that they had to under FERPA. So they made an exception for victims of violent crime or non-forcible sex act. And then in 12 is any person where a violent crime or a non-forcible sex act was confirmed. And keep in mind, a violent crime does include forcible sex acts. So I've got the question as why only non-forcible sex acts are included there. Well, the forcible ones under violent crime. So to any person, so the reason number 12 exists is because there needed to be a database of how many violent crimes and non-forcible sex acts were committed on college campuses, so that prospective students and their parents could look and see whether or not the campus was safe. And so those exceptions, 11 and 12, were made so that the information could be revealed either to a victim in number 11 or to any person in kind of a compilation of crimes on campus in number 12. All right, so how is this enforced? So first, any person, parent, student, may file a complaint with the Student Privacy Policy Office, SPPO, alleging a violation. This has to be done within 180 days of the violation. So if you think a school or a university is violating FERPA, you can file a complaint with the U.S. Department of Education, this SPPO office. So it gives you, it's easy to do. I'm going to show you the page in here in a second. But the determination as to whether or not there's a violation is pretty steep. So first, the determination is whether or not the school violated FERPA. Okay, is what happened a violation. And then they will only find a violation if the second part is met, which is whether the school has a practice or policy of violating FERPA. If it's a one-off, if they made a mistake, they may find a technical violation of FERPA and tell the school not to do that again, but they're not going to find them in violation and sanction the district or the university unless the school has a practice of policy of doing just that. If they have a practice or policy that violates FERPA, then there will be a sanction issued. So there always is a remedial period. So if they find a violation, they will issue the steps that the school or university must take to comply, and then provide them a reasonable period to do that. And then if there's continued non-compliance, then the federal government can withhold further payments made under any federal program. That could be transportation, that could be free and reduced lunches, that could be any federal program, Title I funds. So they can issue a cease and desist letter, or they can terminate federal funding altogether. Now, I have always said that it's never happened that they've terminated federal funding for a violation of FERPA. I don't believe that will ever happen, given the steps that they take and the time they give school districts and universities to comply. If they find a violation, it would just be silly on the part of any school or university not to comply if they were found in violation. I don't know, the environment's a little bit different now in terms of terminating federal funding. So I don't know if that's going to happen. I haven't heard that it happens, at least for this reason, not for a FERPA violation, but that is on the table. This is it is only enforced through funding, hence the picture there. The only thing that the federal government can do, it's a funding clause provision, is if you don't comply with FERPA, a federal law, then they can terminate your federal funding if there's continued non-compliance. This last bullet point is very important. You cannot sue a school district for a straight violation of FERPA. There is no private right of action. It's in the statute. There's no arguing about it. You cannot sue the school district or university because they violated FERPA, even if that violation seems pretty egregious. However, there are other privacy rights that may be able to be pursued through court that might be a corollary to what happened. So if the let's say the information that was revealed was medical related, or the information that was revealed was false, or the information that was revealed was based on sexual harassment. There are other avenues to pursue those types of claims, assuming that a violation of your privacy was actually happened. But under FERPA, you can't, if you filed a complaint and said my university or school district violated FERPA, it would be dismissed immediately because there's no private right of action. This is, I pulled this up today just so you could see it. This is protecting student privacy, the SPPO office, and where you go to file a complaint. You see the nice big button there. It talks about who can file a complaint. It's a parent or an eligible student, and then goes on to give you the link and to fill out a form and file a complaint. A couple recent developments, recent in the last 5 or 6 years. There is a corollary law under Ohio, and that is Ohio Revised Code 3319-321. So state law, really a corollary to FERPA. It really implements FERPA in the state. And by and large, there weren't many differences at all with the state law and FERPA. It still only applies to public schools. It does not apply to private schools in the state. But there was a case that was decided in 2020 called Cable News Network versus Bellbrook Sugar Creek Local School District. And in this case, if you've been in Ohio for a while, you might know this related to a shooting that happened in August of 2019 in Dayton. This was a mass shooting. It was a 24-year-old. His name was Connor Betts. And in downtown Dayton, near the Oregon District, one evening, he shot and killed 9 people and then injured 27 other people. And then he was ultimately shot and killed by police at the scene. He was a 2013 graduate of Bellbrook High School, which was within the district here. And so the Cable News Network and others around the country requested education records of Connor Betts from the school district. And in FERPA, under FERPA, and this is true with most privacy laws, under FERPA, the privacy right goes away upon your death. So that's kind of an exception, or it is an exception under FERPA, is that if the subject of the records is no longer alive, then the records can be produced to a third party, of course, without consent. So death is an exception to FERPA because the privacy right is extinguished upon death. Well, in Ohio, the Ohio Supreme Court said in 2020 that they see that there's no exception under ORC 3319-321 for death. So in that case, they found in favor of the district who was withholding the records and said that they do not have to produce the records to the news organizations, the education records. They're really looking for discipline records to see if there are any warning signs for Connor Betts. They said the district didn't have to produce it because the state law has no articulated exclusion for death. So one difference between the Ohio law and FERPA. One thing with HIPAA, this is pretty easy to reconcile, but if FERPA applies to an organization or an agency, HIPAA does not apply. So it's easy. HIPAA protects health records and it applies to healthcare providers in the same way that FERPA protects education records from universities and school districts. So, you can imagine there's information, there may be information that could be considered health records in education records, like immunization records and counseling records. But FERPA applies to those records because they contain information related to a student and they're maintained by the district. So those are covered by FERPA and HIPAA does not apply. Just a strange little, reconciliation, but that's how it works. And then a couple recent developments, I would say, I mentioned that, information was provided to the health departments during COVID because that was a health and safety emergency, limited to the scope of the emergency itself and the time. Video recordings in general, this comes up a lot with bus videos, hallway and cafeteria videos. If nothing's happening, if the video is just showing students being students, it's just an observation, then that's not an education record. It doesn't necessarily document anything related to any particular student. As soon as an incident occurs, or as soon as that video is documenting something that might lead to discipline of a student, then it becomes an education record. And if you have 2 or more students who are involved in an incident, then a lot of times the school will say, well, you can't see the video. You certainly can't have the video because it's the education record of the other kid. And so, but the truth is you have a right to view the video if it's an education of your own child. And the way schools handle this, which I think is perfectly okay, is that they allow you to come in and view the video, but not record it and not have it. Because FERPA doesn't require that they give you a copy of an education record, but they just give you access. In this case, access means you can watch the video, which is an education record of your child, even though it includes another child, so long as you don't have a copy and you're not recording it. Classroom Zoom recordings I mentioned already, and Zoom observations, are generally not education records unless, again, there's some kind of event that happens which would be documented in an education file. So yeah, I'll end there and take any other questions.
Oh, that's perfect. Thank you, Mark. We have two questions for you. One I'm not sure if you know the answer to, but it is the Department of Education continuing to investigate FERPA claims in light of the recent layoffs?
Very good question. I looked that up this morning because I thought I might get that. And the one note I did get is that the page, including complaints, that allows you to submit a complaint, has a note at the top that says this page is not being monitored currently. So my guess is that they're not taking any action on FERPA complaints at the time if they're saying that the web page is not being actively monitored. So long as the government is shut down, I would say that they're not. Now, I don't know in terms of there've been cuts. And Renee, read that to me again. I don't know if they're asking about the shutdown or the cuts to the Department of Education.
It is the Department of Education continuing to investigate claims in light of recent layoffs?
Oh, okay, got it. Well, it does look like they are, even though they've reduced the size of the Department of Education substantially. At least that's what it indicates. I have not filed one since the new administration, but it does look like they're still, investigating claims, and that the office itself still exists, which is not true for lots of offices within the department. So, but I will say during the shutdown, it looks like it's a no-go.
I will say I'm trying to look up the email, but I did email the FERPA office within the past couple of months. And they did provide a response. Actually, I didn't think I would get a response, but I just had a question on FERPA. And they responded within a week or so. So, I mean, that's not, the complaint process or investigation, but someone was at least answering the emails and gave me a good answer. So that might help answer the question as well. But thank you. The next one is, how long are documents legally maintained by school districts?
Yeah, good question. In Ohio, it depends, in other states too, but Ohio has Ohio school districts adopt a records retention schedule. And then that's submitted to the Ohio Historical Society, now called the Ohio History Connection. But that is a public document that school districts file. So it'll say like personnel files, maintained, for 7 years, student discipline records maintained for 1 year. And that has to be approved by the Ohio Historical Society. I'll use the old name. But that's the state law governs how long they keep those documents. But most documents, special education records, and grades, most of the core education records are kept forever. They're just ultimately, saved through the Ohio Historical Society. And a lot of the categories on the records retention schedule of every school district are, saved forever. But, that's not, I know discipline records in a lot of school districts are not saved forever. They're usually like a year after graduation. I think a lot of districts will keep the discipline records.
Thank you very much. The next two questions are regarding viewing videos as part of educational records. There's one question just asking if there is any guidance document that you've seen that has specifically said that a video as part of as is part of the educational record of the child, so parents have the right to view it, because oftentimes, and I think both you and I have definitely seen this, but oftentimes schools say they won't allow parents to watch the video simply because there are other students in the video.
Yeah, I'll have to look back. I recall the first time I saw it, there was a guidance document, but I think that was in 2013. So I'll have to look back and see if there's any more official guidance or if that still exists. As you might know, with the changeover in administration, some of the guidance has been rescinded, but I can look if you want to drop your I'll give everyone my email address, and if you want to send me an email, I'll see if I can find that. I'd be glad to share it. And if I do find it, we can send it to everybody who attended today.
That was from Chesley, if I am pronouncing that correctly, and she said she will send her email.
I'm gonna put my email in the chat box too for everybody here.
And then just so before I ask the next question, there's one more question. I just wanted to say I looked up that email. I had emailed the FERPA office on Friday, August 8th, and they provided a detailed 3-paragraph response on Monday, August 11th to my question. So they might not be investigating complaints, but as of August, and that again, there's layoffs happening a lot, and I think have happened more recently than that, but they're at least answering questions, so you can try that route. Last question that we have, which is perfect timing because we're right at our end, is just about videos again. What if the district blurs the video that they used in a disciplinary matter, that it hurts the integrity of the video? So yeah.
I think I got it there. Yeah. Yeah. So one way school districts do try to comply with FERPA is they'll blur the faces of other students involved in the incident or in the video, which is perfectly fine. However, here's our take on this. And our take is if we're representing a student who is being disciplined because of something that happens in the video, that student has an affirmative right to see what information and evidence is going to be used against them to discipline them. So if the blur somehow hurts the integrity or understanding of why that student might be disciplined, we would absolutely argue that that should be viewable. And a lot of times, the way we get to that agreement with the district is saying, look, I'm only going to view the video. I'm not recording it. I can't even use the information, which by the way is an observation. I can't even use the information in a way that would violate, violate the other student's privacy. So yeah, we push for it. I don't know if there's guidance to that effect. Whereas if the redactions of the video or the blurring, it affects the integrity. But our take on this has always been, we need to see everything that might be used to discipline the student. And if not, that's a denial of due process in the suspension expulsion, proceeding.
Awesome. Oh, that was the chat. Sorry, I saw a notification on the bottom bar, but it is just your email. So Mark's email is in the chat, mark@education-rights.com. Thank you so much, Mark, for this very informative presentation. I always learn something new from you. This will be uploaded to the website lawyersforstudents.com/legal clinic by the end of the week. And our next month is on Monday, November 17th, I believe, and it is by Steve Pelton of We Thrive Together. And we hope everyone has a good day and look forward to seeing you next month. And since we're getting close, happy Halloween.
Thanks, Renee.
Thank you.